Good afternoon, and welcome to the Cornell University Leadership Lunch and Learn on Knowing Employee Legal Rights. My name is Megan Gerhardt, and I will be your moderator this afternoon. First, I would like to thank Rachel Krug and Juanita McConaughey, co-presidents of the class of 2004, as well as Amanda Massa, who works in the Office of Alumni Affairs, for organizing this Leadership Lunch and Learn. Now let's get down to it. We're very lucky to have such wonderful panelists with us today, and I'm very excited to hear what they have to say. Our first panelist is Jay Woolman, who graduated from the ILR School in 1997, and he also graduated from Georgetown University, where he got his law degree. Jay is an attorney at Randazzo Legal Group in Hartford, Connecticut, and his practice area includes representation of employers and employees in workplace matters, including discrimination on the basis of race, sex, pregnancy and disability, wage and hour disputes, occupational safety and health, and wrongful termination. He also reviews and negotiates severance agreements and covenants not to compete. He brings a great deal of practical legal experience to the table, and I look forward to hearing his employment war stories. Our other panelist is none other than Cornell University's own Professor Dave Sherwin. Professor Sherwin attained both his undergraduate and law degree from Cornell. He is currently a professor of hospitality human resources and a professor of law at the School of Hotel Administration. He is also the director of the Cornell Institute for Hospitality, Labor, and Employment Relations, as well as a research fellow at the Center for Labor and Employment Law at New York University School of Law. Somehow, with all of his free time, he is also a counsel at the law firm of Stokes Wagner in Ithaca. Prior to joining the School of Hotel Administration, Professor Sherwin practiced management side labor and employment law for 6 years. On a personal note, as a hotelie, I was fortunate enough to have had Professor Sherwin as my professor for a number of law classes. His classes helped further pique my burgeoning interest in the study of law, and as they say, the rest is history. I graduated from the hotel school in 2004 and then attained my law degree from Valparaiso University School of Law. Upon graduation, I returned to St. Louis, Missouri, where I've been in private practice ever since. I am currently at Laser Engage, and I work on corporate business and transactional matters. I admit I am not an employment lawyer, and I don't dabble in that area. So like many of you out there, I am very much looking forward to hearing what our panelists have to say and learning about employee legal rights. You should be able to see a PowerPoint presentation on your screen, which highlights the topics our panelists will cover, and then we'll have a few minutes for questions and answers at the end. All right, I'm going to turn this discussion over to our panelists. Gentlemen, take it away.
Thank you very much, Megan. Once again, my name is Jay Woolman, and thank you and everybody else, and Professor Sherwin. I think it's helpful in the beginning to really think about just the fundamentals of what employment law is. It's a relationship between a master and a servant relationship, employer and employee, which arises both out of freedom of association, that is at will employment, nobody has to work for somebody or employ somebody they don't want to, and it's a creature of contract, that is, there are written or oral terms and conditions of employment. The basic one being, I will pay you for showing up and doing X tasks. Everything to think about then is legal until there is something else that renders it unlawful. And we have a number of federal and state laws and areas of law from which this all derives. And the 20th century saw a lot of action on that front, and it continues to expand. We see federal law, such as the NLRA, state laws, and federal laws and state laws may interact, may conflict, and it gets very interesting there and governs the entire corpus.
And I'll jump in by saying that this is one of the things that people are often confused about, and there's this belief that somehow hiring and firing and terms and conditions of employment need to be fair, and that there's this concept of wrongful termination as this amorphous thing that says the termination just wasn't right, it wasn't fair. But as Jay said, that's not the case. We have employment at will in this country, which means we can fire people for any reason at any time, for a good reason or a bad reason, except for an unlawful reason. And the unlawful reasons are laid out. Either it's a contract between the parties, or it's a federal, state, city, local law. But absent that, employees can quit and employers can fire. That's my way of sending it to you, Jack.
Thank you. So with that in mind, we had about a half dozen topics that we're going to be covering, and then there'll be an opportunity for questions and answers. I know several of you have already submitted questions in advance, and Megan will be kind enough to guide us through that. But one of the foundational issues that we see a lot in practice are claims of discrimination. Now, any employment decision is discriminatory. Something is favored or disfavored. The question is whether or not it is unlawfully discriminatory. That is, the hallmark here we have is Title VII of the Civil Rights Act of 1964, where it prohibits discrimination of employment decisions on the basis of race, color, religion, sex, or national origin. And for the Pregnancy Discrimination Act, pregnancy is considered sex discrimination. So that is the foundation that we have for discrimination law, and other things then build upon it. We have state laws, for example, that may prohibit discrimination on the basis of familial status. We have state laws that specifically may address same-sex sexual orientation. Although recently, and I'm sure Professor Sherwin has reviewed this in full, the EEOC has come down to finally say that in Complainant versus Fox, and this was just last month, that discrimination on the basis of sexual orientation is necessarily discrimination on the basis of sex. Now, this hasn't been tested in courts, and I fully expect that a number of courts will not agree with the EEOC on this.
I'm going to jump in on that one. And the EEOC is the federal agency which is empowered to enforce the law. They write regulations on the law, and the courts are supposed to give deference to it, but they don't have to follow it. I see no way that a court can accept the EEOC's argument here, because several times Congress has dealt with the issue of orientation. About 15 years ago, it lost by one vote in the Senate. And the courts and the federal agency can't tell us that in 1964, Congress intended to include orientation when in, whatever it was in the year 2000 or 99, Congress, in fact, debated it, argued it, and voted no. So I think it's very difficult for the courts to infer that, and again, they have to tell us congressional intent. And to Jay's point, Title VII, which includes, has its protected classes: sex, race, color, national origin, and religion. The ADEA gives us age. The ADA gives us disability. State laws will include family status, marital status, and Jay, I haven't looked at it recently. 23, 27 states have orientation, something like that.
I don't count it. I never counted up.
Yeah, but it's around half. Many cities that are in states that don't have it, the cities have it. But as Megan will remember, I hope, the first day of our class together, I fired all the Chicago Bulls fans because
I do recall that, actually.
Okay. And
don't worry, I'm not a Bulls fan.
Not a Bulls fan, so I didn't fire you, but I fired the Bulls fans because I'm a Knicks fan. And that's not protected. And if you don't fall into a protected class, I can fire you for a reason that has nothing to do with work and seems completely absurd. And
what's interesting actually with that example is that there are two ways to prove discrimination. One is disparate treatment. I'm firing you because of your race. Clearly, having a policy that is adverse to somebody, stated or unstated, because of their race, gender, or whatever we're discussing. But then there's a second category. Now, if it turns out that Bulls fans happen to be all of Irish extraction, and therefore it has a disparate impact upon people of Irish descent, this policy, Professor Sherwin's firing of them, while not necessarily disparate treatment, because the category explicitly is not one of the protected classes, statistically it may have a disparate impact upon persons of a particular race, religion, what have you. And so that's why we actually, when we're looking at these cases, we're looking at both types of discrimination areas of proof. how do we prove that discrimination happened? There's a basic outline for direct, certainly, evidence where, you know, I offer to sleep with you, you rebuff me, and then I fire you. Okay, that's pretty straightforward that there's discrimination on the basis of gender, straight, quid pro quo. However, there's frequently then not that smoking gun or not, hey, no more white people in doing this kind of job. So what we have is a paradigm, the McDonnell-Douglas versus Burdine system, where you offer a proof of membership in a protected class, of an adverse action, some other indicia that it was on account of that protected class status, such as replacement by a member of someone outside that class. The employer then will frequently be able to offer a legitimate non-discriminatory reason, and then it flips back to the employee to have to show pretext. With disparate impact, however, you're not looking at that. You're looking at the policy itself and whether or not there is a business necessity for that policy that the employer can state if it is shown that it disproportionately affects a protected class. Most cases, though, are disparate treatment cases that I encounter. It's rare that you do have one of these disparate impact cases.
Yeah, I think that Jay's right. I mean, one thing that disparate treatment, and I always separate the other one and call it adverse impact because sort of simple minds for me, and it makes it better distinction. But disparate treatment is intentional discrimination. That's, I'm not hiring you because you are a man or because you are a woman or because you are over 40 or something like that. And as Jay said, there's a way of proving it. Generally, people don't look at a 50-year-old and say, I'm not hiring you because you're 50, I only like people under 40. The world isn't, employers aren't that stupid. So instead, what you have is the person didn't get hired or got fired, and they don't know what the reason is, and they try to figure out the reason, and then they have to prove their case by proving, one, they were a member of a protected class, and we all are members of protected classes, because it doesn't, if a company decides that they want to hire all women, then I can sue based on gender. I mean, they call it reverse discrimination, but that's not really true. It's discrimination. I have to show that I was qualified. I always have to show that I didn't get hired or I got fired or I got demoted or didn't get promoted. And then I have to show that similarly situated people who are outside my class were treated differently. The employer then has to give, and one of the big misnomers we have out there is legitimate non-discriminatory reasons. That's what the courts say, but that's redundant. If it's non-discriminatory, it's legitimate. Meaning, if you say Bulls fan, and someone says, well, that's not a legitimate reason because my HR professor told me legitimate reasons are business-related. No, it's legitimate if it's not discriminatory. So we just have to say non-discriminatory reason. And then the employee has to prove that that reason's not true. And from that, you can infer discrimination or you need evidence that there is real discrimination. Adverse impact is a statistical game where you have a policy or practice that's neutral on its face. I don't hire Bulls fans. Everybody has to have a high school diploma. Everybody needs to be taller than 5'9". Those things
felons and background checks also are big ones that get litigated.
Well, because I won't hire somebody who was arrested. I won't hire, when you say it's not doing the background check, it's what you've discovered in the background check. So I won't hire somebody who's been arrested. I won't hire somebody who got caught cheating, something like that. And then it turns out that some group, whatever it is, Jay said people who are Irish. I'll say the Amish, or we can say whatever it is. Some group doesn't do well in that class. And when that happens, and I think I just got lost from my computer.
No, you're good. You're good.
You're on.
Okay. So when that happens, then the employer needs to go ahead and prove that their policy or practice has a strong or manifest relationship between complying with that practice and success in the job. So if I say you need to lift 10 pounds and that cuts some group out, if the job is walking around carrying things that are 10 pounds, that's going to be legitimate and that's going to be okay for that policy or practice. If I say you have to lift 10 pounds and the job never has anything to do with lifting, and it turns out that some group can't lift 10 pounds, I'm going to lose. But to Jay's original point, I once did a survey in my law firm. We had like 300 discrimination cases, and we had 0 adverse impact cases because they just don't come up that much.
The only time you do see something like this really come up, and this I think makes for a great segue, is for a lifting requirement and persons with disabilities.
Yeah.
And that usually takes more of an individualized account, because normally in all these other cases, we're not litigating over who is a member of what race or what gender. But one of the big questions with disability discrimination under the Americans with Disabilities Act is who is disabled. And now there are certain people who are categorically disabled, and in 2008, a number of amendments went to clarify this, but primarily you're looking for a person with a permanent a physical or mental disability that substantially limits a major life activity. These are a lot of terms that get litigated. What is a major life activity? Is it substantial? That's why there were the 2008 amendments. Because you're litigating over whether or not they are disabled, and then the next question, whether or not they are able to perform the essential functions of the job with or without a reasonable accommodation. And this is where a lifting requirement gets frequently litigated. Is the lifting an essential function? Also, can the employer provide a reasonable accommodation and engage in the interactive process relative to that lifting requirement? Now, a reasonable accommodation doesn't have to be the one that the employee suggests. It just has to be a reasonable accommodation, and the employer has to work in good faith in the interactive process with the employee to determine what is a reasonable accommodation.
Okay.
And that's what, yes.
Let's just take a step back just a second on the disability, on what is a disability thing, because I think they're separate issues. And it's worth noting that there's a lot of academic work about ADA plaintiffs are the least successful of any discrimination plaintiffs. And the inference from all these law review articles is that for some reason judges and juries don't like the disabled. And I think that's completely wrong. The reality is that if I wanted to bring a discrimination suit, I'm well over 40. It's very easy for me to prove I'm over 40. I pull out my driver's license. I'm over 40. It's very easy in a sex case for the woman to prove she's a woman or the man to prove he's a man. It's not hard. Disability, whether somebody's disabled, becomes an issue. What's a physical or mental impairment that substantially limits, as Jay said? Is it a major life activity? Is this limitation substantial? So plaintiffs lose on that they're not really disabled. So that's an issue that all employers and all employees should understand. Just because I have a condition doesn't mean it constitutes a disability. Then the next step is this concept of reasonable accommodation. And the best case that I've seen to describe it is a case out of the Seventh Circuit, and I think they did a really nice job by breaking it into two parts. The first thing is the accommodation that's requested reasonable? That's looking at it and saying, is society better off if the employer goes ahead and does this? In that case, a woman who's in a wheelchair wanted the kitchen sink lowered. It would cost $150 because she wanted to wash her coffee cup out in the kitchen and not go to the bathroom. And the court said, no, that's not reasonable, that she can still wash her cup out and they shouldn't have to do that. So it's a question, one, is it reasonable? Whether we think that's reasonable or not, that's not the issue. That's what the court said. But that doesn't depend on the employer. That's just sort of a global issue. If it is reasonable, the employer can then argue, I can't do it, I can't afford it, it's an undue hardship. A big company, like that case was the state of Wisconsin, a university like Cornell, Apple, Google, will pretty much never be able to argue they can't afford it. But they could argue that something's not reasonable. A small restaurant with 15 employees might be able to argue, I know it's reasonable, but I can't afford it. In terms of what you do day to day when somebody asks for accommodation, I'll go back to Jay about the interactive process.
Thank you. Now, frequently what happens is somebody is either applying for a job or there's a disability that occurs, or somehow it does come up that this person is disabled, and they have to then put the employer on notice. Now, this should not be confused with the hiring process, of course, where the employer is not permitted to necessarily inquire as to a disability, only whether or not the employee can perform the tasks with or without a reasonable accommodation. So it will come up during the job itself, once you're hired, or possibly while on the job, and then you have to set out what are the parameters of your disability, make sure that the employer knows what you can and cannot do. It doesn't necessarily mean you have to provide every single medical record, but it does mean that a physician's note or report may be required. The employer should consider what are the tasks of the job and fully set forth what are the specific job duties. If the the company doesn't have a job description, it needs to be able to set forth what the job duties are. Otherwise, we're generally going to look to the job description at the time of hiring or otherwise kept on file. And then compare how this person's disability relates to the ability to perform those job functions, determine whether or not they truly are essential job functions, and then whether or not they can be accommodated. This must be part of a dialogue engaged with the employee in good faith. And then they might not be able to accommodate, and that's okay, so long as they actually do attempt to participate in good faith in this process. And then if the employee can't actually perform the essential functions of the job because there is no reasonable accommodation, then any termination decision that occurs or failure to hire that occurs or other adverse action, there's a defense to that claim of discrimination.
And the only thing I would add with that is that employers and HR folks should be aware that just because it's in the job description doesn't make it essential. You can put things in a job description and that happen every 6 months. You're going to need to lift 50 pounds. And it's in the job description, and therefore we require it. And some fact finder is going to say, no, it happens every 6 months. You can get somebody else to do it that day. That's not an essential function. So you need to be relying on your job description. You need to do a great job to make sure your job description, if that's going to be your mantra of what this job requires and why I can't accommodate, that those functions are essential and not just happen sometimes and could be accommodated away.
Right. And speaking of accommodation, there are actually 2 recent cases dealing with accommodations, one in the religious context and one in the pregnancy context. This is from the past term of the U.S. Supreme Court. Some of you may have heard about the Abercrombie and Fitch decision regarding a woman who was wearing a headscarf to a job interview. She didn't explicitly say that she would need to wear it on the job, but the manager who chose not to hire her because he didn't want to have to change the look policy at Abercrombie and Fitch for her, opted to assume she would need that accommodation and then not hire her. The Supreme Court said that the employer did not need to have actual knowledge and that where her protected characteristic was the motivating factor, and so therefore the failure to accommodate was disparate treatment, because Abercrombie & Fitch can potentially accommodate its own look policy, and in fact has. The other being Young versus UPS involved a pregnant woman having a lifting requirement while working for UPS, and that decision is a little more complicated because the Supreme Court did say that the Pregnancy Discrimination Act did not necessarily require the same accommodation as that for the Americans with Disabilities Act, where they otherwise might accommodate persons with back problems who can't lift things, persons who have due to cancer or some other reason. But if they're not going to similarly accommodate, it must be demonstrated by the employer has to demonstrate a legitimate reason for doing so beyond cost. So there could be other reasons, legitimate reasons. One could have a unionized part of a collective bargaining agreement where you offer certain things to employees injured on the job, but you might not do so in the non-union context. But the employer really has a high burden at this point if they're not going to accommodate now pregnant women the same way they might accommodate an otherwise disabled worker.
I think that, and I think Jay's right on. I think when you're looking at these two cases, what you're seeing is the EEOC has a desire to take the terms reasonable accommodation, which is used in the ADA as a very broad standard, and apply it to other areas of discrimination law, beginning with religion. The problem is there's a Supreme Court case that says that religious accommodations need not be granted if they result in anything more than a de minimis effect on the business. That's not the case in ADA. That is the law in religion. The EEOC is not happy with that law and is trying to push religious accommodations into sort of ADA type. But they can't do that. The court has to do that, or Congress has to do that. And unfortunately, in the Abercrombie case, the Supreme Court didn't really tell us where to go with religious accommodations. They focused on the fact that the company refused to hire this woman because it inferred that she was wearing the headscarf because of religion, and they never worked with her to see if they could accommodate or not. But the court didn't tell us that they actually would have had to accommodate, and they didn't overturn the Hardison case. So in terms of religious accommodations, Hardison's still good law, and that says you really don't have to do anything if it's an undue hardship, and undue hardship is defined much more broad than it is in the ADA. With pregnancy, Jay's right. That case is really messy. It doesn't explain what you need to do. There's a lot of stuff going on because the company had a light duty policy for workers' comp and ADA. If you have light duty for workers' comp, you must have it for ADA. The court made it easy to infer that if you have it for workers' comp and ADA, you need to have it for pregnancy also, but they didn't expressly state that, so that's kind of open. And the court didn't say whether or not if you don't have light duty for workers' comp, you need to do it for pregnancy. If I were advising a client who said to me, a pregnant worker needs light duty, we have it, we can do it, but do we have to? My response would be, I would probably do it because the marginal cost of providing it is a lot less than fighting it. However, if you have a workforce of young women and they're getting pregnant and you can't afford to, and you don't really have light duty, this case doesn't say you need to provide it. This case,
exactly.
It's more confusing than it is answering the question.
Now, speaking of confusing and answering questions, there's also certain foundational issues, and we're running short on time at this point, but confusing things abound in employment law. One of the issues that we frequently arises in wage and hour law of who is an employee versus who is an independent contractor. And it may be that your person that you're paying on a 1099 independent contractor is in fact an employee, and we see a lot of litigation over that. And there are different definitions between the IRS and the Department of Labor, and we also see a lot of litigation over who is exempt from overtime and minimum wage law and who is non-exempt. That's really the terms that we use. I know it's kind of funny that negatives there, but as to who is covered and who is not covered in the hierarchy of whether or not you get overtime and minimum wage. And the rules are changing. There are different agencies and courts with different rules. States and federal agencies and courts may have different tests on these very same questions, and it is incredibly complex at times, and you just need to keep in mind that people you as non-employees not entitled to overtime, you could wind up getting sued over and have to pay double or triple damages for an entire class of workers and pay their attorney's fees. So this is very risky, and you need to be careful when dealing with people who aren't employees but are kind of quasi-employees, because they may truly be employees.
Yeah, I want to jump in. I think Jay's exactly right. These wage and hour lawsuits, when I was an ILR undergrad, were barely discussed. When I started practicing in 1990, all the employment law firms I knew had one person who sat in a windowless office, and he or she was the wage and hour person, and we laughed at that person because who cared? Now they're bet-the-company lawsuits that are driving employment law practices and are the biggest fears of employers who are in labor-intensive industries. So now that's number one. Number two is that in the old days, what you had was if you misclassified somebody and you didn't pay them overtime when they deserved overtime, you could generally say, "Hey, I messed up. I'm sorry," and your penalty was just paying the overtime, because you only doubled the damages when it was willful. And willful meant, I know this person isn't truly exempt, but I'm not going to pay him overtime because that's the kind of person I am and I want to save the money. That was willful. Now, many courts have said when you misclassified them, your act of misclassification, even though you didn't mean it, was a willful act because you actually did it. So right. Now what happens is when you misclassify someone, it is almost automatic that you're going to owe them double damages, plus costs and fees. So now when you refuse to pay someone time and a half, that you just paid them time, now you're going to have to pay them not just, their half, but you're going to have to pay them, or, you're going to have to pay them, double that.
And this even happens with industry practices. Entire industries get affected. The Second Circuit just hit up Skadden Arps over attorneys who are doing document review, saying that they're really not exercising the type of independent judgment of an attorney, and so these document review attorneys may actually be entitled to overtime, and that has still to be litigated in the lower court. Yet this is a standard practice throughout the country, throughout the entire industry of big law firms, doing massive discovery projects.
Again, as Jay said, I know we're getting close with time. When it comes to wage and hour classifications, whether someone's an independent contractor, whether someone's exempt, non-exempt, whether the person's your employee or not, in this day, the Obama administration has made this an issue. David Weil is the chair of the Wage and Hour Division of the Department of Labor. This is what David is focusing on. And they are zealous in their enforcement. I think any employer that has a significant number of employees is foolish to not bring in outside counsel, and I'm not advertising because I don't do this, but not bring in outside counsel to do a labor a classification audit and make sure that every employee is classified correctly. Because if not, you can wake up one day and find that you owe an amount of money that the company just doesn't have on hand.
Right. And frequently, and as a practical matter, you may even insure, your employment practices. Your company may have an EPLI insurance policy. However, most EPLI policies, while they cover discrimination, they don't cover wage and hour claims. So again, what are you going to do? You hire a lawyer, or one of the things about hiring a lawyer, while I'm not advertising it again per se, is guess what? If I get it wrong, sue me. I have insurance. So you have more protection by having somebody outside, give their blessing to your, give an audit to your categorization, and then if they're wrong, at least you have a measure of recourse.
And the other thing is that there are times that things are close calls. I have sat at a table with general counsels from major hotel and restaurant companies, asking them if they want to comply with the Fair Labor Standards Act. They all say they do. Asking them if they know how to, and they all say they don't. That there are certain employees that it's an unclear standard. Now, if you err on the side of saying this person is an employee and they are non-exempt and I pay them overtime, you can't lose. You can always there's no liability by saying I'm going to pay them hourly and I'm going to treat them as non-exempt. They are my employee, they're non-exempt. You have no risk. If you decide to say they're an independent contractor or that they're exempt and such, I'm not paying overtime, there's risk. Now, sometimes there's no legitimate risk because the CEO, we pretty much know, is an executive exemption. But there are other people that are risks, and you as an employer should understand that and say, okay, I think we're right, we're going to roll the dice, or, okay, I don't want to risk this, I'll pay the people overtime.
I think we should probably leave a little bit of time now for questions, so I'll probably skip the whole NLRA section. I just want to note that employers should be careful because the NLRB is looking at concerted activity that is occurring outside of the union context. So even if there's a non-union, no organizing, no union there still may be unfair labor practices that occur. So just be careful about anything that an employee is going to do that may affect other employees. Megan, did we have questions?
I'm sorry, go ahead.
Megan, Jay's right with the NLRA. The big thing to look at are your social media policies, your confidentiality policies, and any policies that somewhat limit the employee's ability to communicate. The NLRB is looking at under a microscope. That's where the NLRA kicks in, and that's when the board will start investigating. And now, Megan, talk to us.
There was a follow-up question on the Abercrombie case, and the question was, did the candidate need to disclose that her religion required the headscarf and she would need an accommodation during the interview?
Well, that's what the case was really about. She didn't, and Jay, tell me if you have a different interpretation. The woman in the case did not. The plaintiff did not, and the company was found, and the company inferred that it was because of religion, and inferred that she would need to wear it, and then didn't hire her. And
right.
And the court said that was unlawful. So no, she didn't need to do that in order to win. But winning lawsuits is a stupid strategy to begin your career. So
right.
It makes a hell of a lot more sense for a person who has to wear certain clothes or whatever their religious obligations are. It makes a lot more sense to say, hey, look, this is my religion and this is what I'm going to need as an accommodation, and get it out there instead of not telling and seeing what happens. And then this case went to the Supreme Court. It took years.
Right.
Right.
not a victory for her, and she's very lucky that she found a plaintiff firm that wanted to invest all that time in this kind of case. Because a lot of people look at it and say, this is an open issue, I'm not sure, it's not clear, no thanks. So I would say, as a practical matter, just say what your accommodation is you need. If they turn it down, that's a much better case.
And practically, she had, some strokes of good luck. There were records that demonstrated this is why they were taking that action. That rarely happens. So 9 times out of 10, she's not going to know. She'll presume, but she's not going to know this is why she's not getting the job or terminated. So, I'm not going to take that case. I'm not going to risk it because I can't prove it. I don't have the evidence. Is what, you can guess at, probably, but me spending thousands of dollars in my time to take that case with, a very small likelihood of recovery, probably not.
And then you throw in the last part, which is that she didn't win. The case is going back to begin again because they're going to argue it's an undue hardship. So, they may settle, but at this point, all that she found was that this was unlawful at that level, but now they can argue undue hardship. At least that's what one of the justices said in a concurrence. So I'm not even sure if it's a true victory at this point. So yeah, be forthcoming and honest. It's a much more efficient way to live your life.
All right, good advice. Well, we received a few questions in advance when people signed up for the webinar, and I found this one to be very interesting. Now that a number of states have legalized medical and/or recreational marijuana use, how does this legalization impact the rights of employers who want to perform drug tests, as well as the employees that are the subject of those drug tests?
Medical marijuana and recreational marijuana presents an incredibly interesting issue, but it's also not as interesting as one might think. For years, employees have been prescribed oxycodone to treat conditions. So employees having narcotics in their system is nothing particularly new. However, what many of these states, Colorado, for example, being the big one, where they have in their laws that the employer can't discriminate against the employee for using the marijuana. So that's what may happen in some states, that the employer can't do anything. Other states may say, well, they can they can't discriminate where it's for medicinal marijuana, but not recreational. However, there's also federal regulations, such as Department of Transportation regulations over truckers, where testing is required, and it doesn't matter. It's still a Schedule I. The employer can't hire a marijuana user, even if it's medicinal, to do cross-country trucking. It's against DOT regulations. The employer may also be able to, and most of these laws certainly say that the employer can require that the employee not be high on the job at the time. What'll be upcoming, though, is whether or not under the Americans with Disabilities Act, an employee who uses medicinal marijuana may request a reasonable accommodation from a marijuana policy to the extent that they may be able to perform the essential functions of their job while using. I don't know what their job might be. I'm not going to try to speculate what that job is that you can perform while using marijuana, but there may in fact be certain jobs that just require you to sit in a chair all day and be a body. I don't know what that is other than certain political jobs, but beyond that, it's a burgeoning area, and it's going to vary from state to state. And it's something that really employers and employees need to think seriously about and consider how this will affect them. Talk to counsel, talk to their physicians, talk to HR, and make sure that they are all fully informed, because this is a new area and there's going to be a lot of litigation.
Yeah, I think the one other thing is that absent some states have statutes that say that you can't fire people for off-the-job legal activity. And if if a state were to allow, were to follow Colorado and Washington and D.C., and I guess Oregon too, were to follow that and did not have a statute that a privacy-type statute that protected you from being terminated for engaging in legal conduct, then an employer could say, look, I understand that my state allows marijuana use. I just don't like the drug and don't want to hire people who smoke pot. And an employer could do that absent that statute if it was purely recreational. If it was used for medical purposes, that gets a little more interesting because an employer could still argue, I don't like folks who use marijuana for medical purposes. And then if the person were not ADA disabled, I think that the employer would have a really strong argument. I use this because I have trouble, it helps me sleep. And if not, I have insomnia. Unless you could argue that this insomnia substantially limited the life activity of sleep, if it weren't an ADA disability, then my take on it would be the employer would be free to say, that's fine, I'm happy that it helps you sleep, and when you wake up in the morning, you can go work somewhere else. That's my take right now, absent statutes to the contrary.
Yep.
Well, it'll be interesting to see how this develops as more states legalize medical and recreational use. We're almost out of time, but why don't we do one more question? A number of people submitted questions about pregnancy accommodations, maternity leave, things of that nature. Is discriminatory termination on the basis of pregnancy, or an explicit refusal to promote based on pregnancy problematic? How extensive are the protections given to pregnant employees? And what happens if they're terminated while pregnant? Do they have any rights or remedies that can be applied to them?
I mean, my take on that it's like anything else. If I fire you and I'm stupid enough to say, I'm firing you because you're pregnant, I don't like pregnant people and I'm firing you, that could be a sex case, a race case, a religion case. It's the same thing. It gets a little funky when you say, well, why didn't I get the promotion? Well, I needed the promotion for somebody today because the job that you're filling was held by somebody who's leaving tomorrow. So I need to hire somebody. I need somebody in that job today, and you are about to start a leave, and you've told me, pursuant to our policies, you're taking 6 months. So I'm not giving you that promotion because I need to give it to somebody who can start working today. And I think in that case, the employer would have a non-discriminatory reason as to why they gave it to the non-pregnant person. And I think, that would be subject to scrutiny, but if it passed the scrutiny, that would be that. So pregnancy is just like any other protected class. You can't base your decisions on it. But if you have a legitimate reason as to why as to why you didn't hire or you fired somebody who's about to take a leave, I think that'll stay lawful. Jay, what's your opinion?
Oh, I agree. And pregnancy does other complications or other issues of law in the workplace that there may you as an pregnant employee may need to an employer the employee's rights under the Family and Medical Leave Act up to 12 weeks of leave. State laws such as the Massachusetts Maternity Leave Act provides 8 weeks of specifically maternity leave. There may be your own internal policies or insurance policies regarding short-term, long-term disability that needs to be considered. And should there be any medical further problems, even the ADA could be implicated, where there is some kind of permanent disability arising. And so there's a whole host of rights and responsibilities for both the employer and the employee to consider when we have a pregnant employee who needs some form of leave or accommodation. However, the only thing to remember is really don't do something against an employee because she's pregnant. However, the pregnant employee is also still subject to the same downturns of problems with that every other employee faces, such as if there's a layoff, a mass layoff, and you're on maternity leave, well, that doesn't insulate you from the mass layoff either.
Yeah, but again, just like anything else, you need to be careful. If you're about to lay off people, and you're laying off 5 and keeping 10, and you lay off the pregnant person, that person's going to say, "Oh yeah, I was chosen because I was pregnant," and you're now going to be defending as to why that person was chosen, and you just need to make sure that you have objective reasons, and that it's not like, hey, out of sight, out of mind, it was easy. All I had to do was write them a letter. I didn't have to look her in the eye. But yeah, I think that it's a protected class and needs to be treated as such.
Right, and the same thing say for age and mass layoffs also.
Right.
Just that comes up a lot, but everything is lawful until it's rendered unlawful in this situation. So really, unless you can show that there was discriminatory motivation, bad things can still happen to you despite these protections.
Okay. Well, on that note, we are out of time, gentlemen. Thank you so much for your time and insight today. I think that this was just a fabulous webinar, and thank you to everybody who dialed in and participated in this. We really appreciate it. I think it was great.
Thanks very much.
Megan,
All right.
thanks.